guys. Please be seated. Good afternoon. This time it's the afternoon. So good afternoon. Court is in session again. And I see that we have a greater turnout than in previous days. Welcome to everyone on this last day of the defense's oral arguments. And you've been putting forward your oral arguments over the past 10 days. And today is the day in which you will put forward your conclusions, your closing remarks. You have the floor. President of the Court, members of the bench, members of the prosecution, ladies and gentlemen. Everybody knows who the guilty person is, but that's not how the law works. That was what we read in the first paragraph of an article published in a Dutch newspaper that was published somewhere in the course of our oral pleadings. What does the journalist mean? I thought, hopefully, that he may have meant the first part of the sentence in a simple justice has yet to be administered. After reading the entire article, it becomes clear that that is not what he means, that he simply means what it says. Everybody, including himself, everybody knows, between inverted commas, who the guilty person is. It's a matter of getting the trial over and done with. Prying open the truth, that is what lawyers do. The more you zoom in on details, the less you see the wood for the trees. That was also a quote from the same article. And that is how this journalist understands the work of the defense to be. And in the course of our work, in this case, we were often faced with the fact that many people apparently believe that lawyers are only putting up smoke screens, trying to make sure we can't see the wood for the trees by zooming in on insignificant details and vague suggestions. That doesn't do justice to defense counsel. Most lawyers really do more, and that is precisely what we set out to do more than just simply cast doubt. I'll be discussing that in a moment. Because anybody who appreciates the importance of a fair trial understands why justice should take its course. For these people, a trial, if it has to have any real value at all, a trial is much more than simply a formality. That's the case from a legal perspective, which is what we focus on, but also if we reason from the perspective of a defendant, from our client's perspective, the person who is suspected of being co-responsible for this unspeakable suffering. And also, if we take the perspective of the suffering as a consequence of a crime, both our clients, the victims, the relatives, and anybody who has been affected by the crash in any way is entitled to the truth being revealed. And chances are that the truth will be revealed if the trial is more than a formality. A trial in which facts, suspicions, and assumptions are reviewed from several perspectives, and are subsequently weighed up and assessed. A trial in which there is room to review what appears to be certain and to do so very carefully. And it's not only lawyers, suspects, relatives, and other interested parties that are shortchanged by considering the law as the last decision with respect to an established fact. The law as such would then wrongly be downgraded to a necessary formality, a matter of going through the motions. The purpose of the law is to make sure that the facts are first weighed up by a court before establishing what the truth is, before anybody could know who the guilty person is. And subsequently, the court is more than just an institution that uses a gavel to confirm and formalize what everybody already knows. The court can only declare the charges proven if the court is absolutely convinced that there's been a fair trial, and on the basis of this fair trial, there is conclusive evidence that things transpired as one of the parties of the proceedings, public prosecution, believes they have transpired. And if a fair trial leads to the court finding that those facts cannot be established, then that is not a legal formal drawback. It's just the fact that the facts are not established. And the facts have simply are very important. And however horrible it is that the much sought after truth is not revealed, I do trust that people, and particularly people concerned here, would ultimately prefer that as opposed to a belief in an incorrect interpretation of facts. That is the way justice should work. And I have wondered whether everybody would actually realizes how terrible it would be if the justice system wouldn't work. If the justice system would just be a necessary formality in which everybody already knows who the guilty person is. How terrible that is something people only realize if all of a sudden they stand in the docket. Not in the courtroom, not watching a live stream, not reading a newspaper, no, in the dock. Only then do people realize how important it is that justice is actually administered and that charges are not confirmed without further investigation, and that investigation results are not subject to a one-sided interpretation but are considered from several perspectives before judgment is handed down. And for those of us who do not realize that, it would be really scary if the justice system would work in such a way that it would only be a necessary formality in the cases in which everybody already knows who the guilty person is. And this applies not only to those cases in which there are suspects that everybody understands to be guilty. In those cases, premature convictions don't really lead to problems. The errors occur precisely in those cases in which everybody supposedly knows who the guilty person is, but when that guilty person turns out not to be guilty. I'd like to mention the cases of Lucia de Berg, case Bosboom in the Schiedammer Park murder, Wilco Fiets and Herman Dubois in the Puttens homicide case, Ina Post. And these are just judicial errors that occurred in our country. Everything pointed to the fact that the suspects in those cases were the guilty persons. Everybody was sure about it. Nonetheless, that was not what it was. In those cases, the justice system almost didn't work as it was supposed to work. Unfortunately, after years of injustice, everything ended well. But this is something we need to learn from. Not everything is as it may seem. Not even if it seems as if it cannot be coincidence. And not even if lots of people really think they are quite sure. Because precisely then, when almost everybody is pretty sure, that is when injustice lies in wait. It is a sad and worrying conclusion that most people in the Netherlands, in this case, don't seem to have any room for doubt, not even for giving doubt a chance. At least, not if we follow the narrative of this article. This article, on the one hand, puts forward good reasons for doubt, such as contradicting missile evidence mismatches with reference material. Nonetheless, these observations, according to the journalist, do not lead to even the possibility of doubt, but lead to the conclusion that these are cleverly formulated lawyers' words to pry open the truth. The truth, not the interpretation of public prosecution, but the truth. Many will think, I'm sure a certain degree of doubt is very important, but there are simply so many indications that have been put forward that it was a Russian missile. We've heard so many arguments to that effect, and the authorities that we trust say that they're so certain about it. We did have room for doubt, but we know what happened. And indeed, why would you have any doubts if the Dutch authorities say that they're quite certain? Why would you doubt after having heard all those arguments and indications? Before I answer those questions by touching upon the counter-indication and the other side of the story, I really hope that everybody who really believes they know for sure, at the very least, would be prepared to do some soul-searching and find out why they are so convinced and what their certainty is really based on. The answer in any case cannot be, because everybody is aware and familiar with the case file, with the exception of the parties in the proceedings and the investigators they commissioned. Nobody, almost nobody, has access to the case file. So that cannot be the knowledge, the basis of that knowledge. Is it then because everybody saw videos of a teller that was transported in that region? We don't even know whether the teller could fire a missile, nor do we know whether the teller did fire a missile. What we do know is that there was a war going on and that the teller there, unfortunately, was nothing out of the ordinary, and that the Ukrainian armed forces in that same area had 27 tellers and 157 Buk missiles. So the presence of one teller is not such a coincidence that things have to have happened this way. That cannot be. It doesn't mean a lot. Is it then because the JIT has shown how the teller drove onto the field and fired a missile that then struck flight MH17? These are computer animations, imaginations that settle in people's memories, suggestions and visualizations of what the JIT believes happened. Is it then because the missile has been found? And would that be the casing that was shown to the world? The prosecution doesn't even use it as evidence. The prosecution didn't even answer the question whether that casing had anything to do with flight MH17. Or is it because the separatists in telephone conversations say that they are responsible? They don't say so. This is implied by selectively putting certain parts of certain conversations in the wrong context and attaching wrong meanings to words, whereas other conversations are not discussed. A suggestion that is also based on the worldwide publicity that was given to certain conversations, such as the bird conversation, whereas there was hardly any publicity around the fact that investigation then showed that this conversation had nothing whatsoever to do with MH17. Would it then be, if all this is dismissed, is it because the JIT and prosecution say that they're so sure that this is what happened? What we should in any case realize is that all these arguments, indications, and we know for sure only constitute one part of the story. A story that does not contain all the indications and counter-indications. It's one vision, one position, one conviction. All the we know for sure are based on the JIT's investigation result. These are the investigation results that prompted the public prosecution, MPs, the Prime Minister, and other authorities to say, we are sure. And someone pointed out that lots of people aren't really bothered by such a one-sided version or rendition of the story because everybody assumes that the investigation was flawless and the investigation was carried out by the best and the brightest of the JIT and prosecution. It is a fact that even the best and the brightest can make mistakes, and even the best and brightest cannot always resist information and confirmation biases, cannot resist the input of the SBU, the Ukrainian Secret Service that plays such a prominent role in the investigation, cannot resist the enormous restrictions of this investigation in an area that was inaccessible and in war conditions. And furthermore, the best and the brightest really did make mistakes, and they did lots of things really well, and they moved impressive mountains of work. I'm not going to deny that, but they also made mistakes. Reference missiles were fired the wrong way around, pieces of wreckage were switched, possible pieces of evidence contaminated each other. Experts, hindered by enormous restrictions in knowledge, were consulted without looking for the right knowledge and experience. Lines of investigation that were not understood or that didn't fit were not subjected to thorough follow-up investigation, and particularly not in accordance with the ICAO standards. And certain decisions in the investigation were based on incorrect convictions and accessory findings that turned out not to be any evidence at all. And time again, when we approached experts or examined experts, they expressed their amazement at the way in which the JIT carried out its investigation or had it carried out. That was an experienced missile expert, internationally acknowledged and experienced airplane crash investigators, a telecom expert used to international trials and a completely different level of investigation, legal psychologist with a PhD in the reliability of witnesses. Those best and brightest felt had a fair bit of criticism with respect to the JIT investigation, and they had great concerns about the correctness and reliability of the results of those investigations. So in short, there are more than enough good reasons to assess the results of the investigation of the JIT with great caution.
We also understand that nobody wants errors to have been made. Nobody wants to question research results presented as certainty by investigative institutions. It's unfortunate and disconcerting to have to doubt. It's far more pleasant and reassuring to be able to rely on such institutions and to assume that they did their job right, especially in this case, in connection with that so broad and widespread intense sorrow about that truly horrible experience. Everybody longs for the government to have done things the right way, and everybody needs clear information about the circumstances and confirmation of the truth. But if you realize that investigators are only human and may have made mistakes and were under enormous pressure to find the answer and not to deviate from that answer that they provided so prematurely, do we all want to rely blindly on the certainty of one of the parties to the trial that we are no longer even receptive to other arguments and counterindications? Yes, room for doubt should be limited, but that limit should never be reached before the other side of the story has been heard. And specifically, those who consider this case to be important should at least wait until after that point to question the knowledge as to who the guilty party is. If that is determined unquestionably in advance, so that it's not, then nothing could be revealed by this case. If there is no doubt to question accuracy, if there is no room to question accuracy, then the trial means little and is merely a reassuring cover for claimed certainty. And that desire for a fair and meaningful trial, that means, however difficult it may be, that everybody should commit to it and should seek out that room for doubt or retain it for a moment. Room for doubt, i.e. for allowing the uncertainty that, after all, exists. And that also means that part of the story, especially since the prosecution's view has been publicized in so many ways and so widely, that other side needs to be publicized too and should be given a chance. And realistic questions and defenses, even if they seem insignificant, should be given a chance and should not simply be dismissed as illogical, as important details, or as conspiracy theories. That certain possibilities, such as the effect of military deception strategies and manipulation of evidence by secret services, are difficult to imagine. However, this does not justify dismissing questions. After all, it is difficult to understand all that can happen in warfare, and it is tough to find out what the secret services of former Soviet republics are capable of, but that doesn't mean that it cannot be true. That certain details may appear insignificant does not make them such. An element composition of a missile part may be one of countless details investigated, but if that detail is in fact at odds with other findings, then it is very important. After all, then that reveals that that cannot be evidence of the JIT scenario and may be an indication of what did actually happen. Giving justice a chance requires listening and assessing all other arguments without bias on their merits and keeping in mind the limits of one's own knowledge, skill, and empathy. To avert miscarriages of justice, it's crucial to give doubt a chance. Creating doubt is not an unfair trick by lawyers. Allowing for doubt is necessary to form a good opinion. First, room for doubt and room for retaining questions, so that all indications and counter-indications are heard, and so that all arguments and counter-arguments get a chance, and to weigh them and compare them with each other, and afterwards to reach a decision and turn the question mark into a period. If that space ceases to exist prematurely, the other side of the coin emerges, which nobody wants either. Nobody wants to believe a version of the truth that may not be the truth at all. After all, we want not only certainty, we want certainty about the truth. We truly hope, and I believe together with us, Lucia, Ina, Case, Vilko, and Herman, hope that the answer to that question is yes, that the counter-arguments and that the counter-indications and arguments we have put forward are given a chance, and that they are not set aside regardless of their force or content, and are just regarded unfairly as intended to create wrongful doubt. The arguments and counter-indications that we have mentioned in the past 10 court dates do not bear repetition here. It's not feasible, and we wouldn't want to do that to the court or to our faithful listeners. I will summarize a selection from our arguments to convey an overview of the cohesion between the different sections put forward. And it's possible to lose sight of that otherwise over the course of 10 days. And for those who want to know the foundation of all those arguments and the other arguments and interlocutory decisions, please see the pleading notes from the previous days in court. First, the question as to whether a fair trial is possible. That question starts with the way that the JIT and the prosecution conducted the investigation. It turns out that in the prosecution's investigation, the focus was almost entirely on evidence that matched their own scenario, while nonetheless giving the impression that other scenarios were taken seriously. That impression was given, for example, by relying on reports drafted by investigators that lacked expertise in the specific area required. This impression was given, for example, by failing to conduct a complete investigation into other launch locations or an Su-25 that may or may not have been hit on 17 July 2014, while noting in court that nothing indicates the launch took place from elsewhere and that no remnants were found of an Su-25. These arguments can be legitimate only if the investigation was full and complete. The question is then whether the prosecution, given all the financial means and capacity available for this investigation, invested correctly. A case file of 65,000 pages and many years of work is impressive but reveals little about the question raised. Based on many examples, we have demonstrated that the prosecution, especially in the event of contradictory findings, did not make a maximum effort to investigate those findings. For example, no experimental investigation was conducted to check whether the location where missile parts were found was to be expected or even possible in the event of a launch according to the JIT scenarios. So the NLR was not instructed to conduct an investigation based on an old model, an old warhead, or another surface-to-air missile. The NFI was not provided with a missile detonator when PETN was found, and after receiving the positions of Almaz Antay, nothing was added or adjusted to the reconstruction in Khilzarei, and the suggestions of the NFI for additional investigation were not followed. And finally, no soil samples were investigated, as a consequence of which the likelihood of clear answers regarding forensic launch evidence is by definition excluded. But aside from findings to the contrary, within the own scenario, there was insufficient time invested in the RMA arena tests. Against the advice, only one arena test was conducted, which was far from perfect and can therefore not be deemed representative to sufficiently accurately determine the dynamic fragmentation pattern of a book missile. Equally concerning is that the results of this test were the foundation for subsequent investigations by the NLR and the RMA. Those subsequent investigations, which concern the question as to what the launch area could have been, were then based on different premises. For example, the expert retained for the JIT did not receive all the relevant information. The cause is the asymmetric information, which was not resolved during this trial, and that would not have been necessary if during the preliminary investigation the investigating judge had more control, which unfortunately was assigned only as a commissioning authority by the prosecution and was materially out of the picture. The substantive control of the prosecution is also manifests from excluding nearly all material not related to a book missile and generating investigation hypotheses, so that the NFI was not able to do useful probability estimates. Only afterwards did the true evidentiary value become clear, which was that not a single fragment was found that could be deemed with beyond any uncertainty to appear in the warhead of a book missile. The NFI was never given the opportunity to investigate warheads of other missiles that might have caused the damage pattern found on the reconstruction site. In those decisions, the prosecution from the beginning of the investigation was simply guided by what the SBO disclosed so soon after the crash. The professional distance of police and prosecution in other cases was not visible here. If we're talking about the scenario where the Ukrainian armed forces, perhaps once again mistakenly, like in 2001, could have launched the missile in question, how can we know that the prosecution was not simply guided by excessive trust in the question as to whether a certain institution could be a potential suspect? Because neither the prosecution nor the Dutch government discloses anything about the decision to team up with SBU at the time, this question has remained unanswered. One condition for a fair trial is in part, not exclusively, but at least that the prosecution has conducted independent and adequate investigation. That was not the case, in our view, is especially urgent because other conditions for a fair trial have not been met either, such as the condition that the defense needs to have had enough opportunity to investigate all question marks and that sufficient room must remain for an open assessment of the evidence put forward. The defense needs to be able to contribute to the preliminary inquiry before a suspect is put on trial, and this was deliberately blocked by the prosecution so that the court received a case file that was not ready for trial with all additional and inevitable influences. And therefore, in court, many requests needed to be made for additional investigation. As a consequence, during our oral arguments, we had to mention repeatedly that, in fact, finding much valuable forensic and other types of investigation was not conducted, and in retrospect, too many requests for investigation were wrongly denied, and this led to conditional requests which intrinsically indicate the observation that the present case file remains incomplete. All of this has compromised the defense and ascertaining the truth and directly arise from the decisions by the prosecution that were proclaimed at a press conference on 19 June 2019. At all press conferences of the JIT and the prosecution, the primordial requirement and rule of law of a fair trial have been overlooked, and this put the defense at a serious disadvantage and fed potential witnesses which alleged info known only to the offender. This combination of leading public opinion and at the same time violating the rights of the defense by failing to give the defendants an equal chance in the preliminary inquiry make the actions of the prosecution objectionable. The prosecution therefore has a still greater responsibility to conduct careful, complete investigation, but that was not done. Given the above, is a fair trial possible in the sense of Article 6? Under those circumstances, is there a true opportunity that the questions by the defense may potentially lead to acquittal that could be appreciated by the public? Given the limitations of the investigation by the JIT and the limitations to the defense, given all statements by authorities that everything was believed to be so certain, given that broadly sustained political conviction about that certainty, given all those times that in passing we were asked whether we truly believed that acquittal was possible, we are not relying on that. Still more important, and all the more remarkable, may be that despite all the limitations in the investigation, in the end it is highly questionable whether it was in fact a book missile. In questioning the missile identification, we argued that the investigator dealing with the question as to whether other missiles besides a book missile could have caused the damage pattern on the MH17, that investigator lacked a sufficient expertise for that type of investigation and therefore excluded many other missiles, nor was he sufficiently independent to answer that question because in previous reports he had already concluded that it had been a book missile. In addition, because he had nothing else, he needed to use insufficient and unreliable source material in his investigation. Nonetheless, even according to that investigation and that investigator, theoretically, other missiles are possible, and in our view, many other missiles would have been possible. The NFI subsequently conducted an investigation that was unilaterally focused on one missile, the book missile. Among the evidence to be investigated, the NFI, at the intercession of the prosecution, disregarded nearly all material that could not have been from a book missile by selecting such metal parts for additional investigation, for example. There is only a reason to investigate all metal parts that they thought were related to a book missile. The possible book sections found at the crash site were compared with metal parts from a previously unused reference book missile that was taken apart, and metal fragments were taken from the warhead. No such investigation was conducted on the 4 other missiles, which, according to the investigation, or with respect to the other missiles from our perspective, these 4 others could theoretically have been a possible weapon. And the metal parts were deliberately not compared with those missiles. During the interviews by the NFI investigators, questioned by the defense, it also became clear that the distinctiveness of those metal parts from the crash site was never investigated either. As a consequence, it's not clear how unique these metal parts are, or whether they exist only in book missiles, or whether they also exist in other theoretically possible missiles. It cannot be ruled out that the metal parts investigated at the crash site could have come from a different type of missile. Remarkably, the experts did not identify a missile with sufficient certainty based on the damage pattern of the MH17 wreckage, the reconstruction. This damage pattern was investigated only based on the principle that it was caused by a book missile. So where did that book missile then come from, if it was a book missile? That's the question asked in connection with the damage pattern on the wreckage, and that was a missed opportunity because the damage pattern as such could potentially reveal a lot about the type of missile that it was or could have been caused by, but the prosecution did not investigate what damage other missiles would cause if they had been detonated, let alone which damage, if that happened in proximity to an aircraft at an altitude of 10 kilometers at a certain speed, nor did they investigate whether the damage pattern was distinctive of a book missile, and not at all whether that damage could exclusively have been caused by a book missile. Once again, it could not be determined what type of missile caused the explosion, so no technical or experimental investigation took place to rule out missiles other than a book missile. The conclusion is therefore that the MH17 could indeed have been hit by a missile other than a book missile. About 8 months after the crash, at about 24 kilometers from the launch site selected by the prosecution, parts of a book missile were found. How these parts ended up there and whether they were there before the crash or ended up there sometime afterwards was not investigated by the JIT. These parts were from both an old and a new book missile. Whether the area where these parts were found was the place where they originally found was unknown, nor is it known who found those parts. In 2018, at a press conference of the JIT and the prosecution, these materials were shown to the world, but in 2021, the prosecution did not present them as evidence of the missiles said to have caused the MH17 to crash. We have questions about this to the prosecution, but to date, they refuse to answer those questions. It is known that there was a registration number on one of the parts found, based on which it can be attributed to an old model book missile, the 9M38, and it's also known which Army unit was supplied with this book missile. According to the manufacturer's records, that's now a part that pertains to the Ukrainian armed forces. Is this why the prosecution didn't mention it in presenting the case? Question mark. The 2 metal parts, the lumps that the prosecution does mention in presenting the evidence to show that they came from a book missile, do indeed comprise chemical properties found in a base and a sliding panel of a book missile. Such panels and chemical properties also exist in other missiles and are made of ordinary steel. Once again, these other missiles were not investigated, not even relating to the question about these two lumps. So the NFI cannot make any clear statements as to whether these lumps do indeed come from a Buk missile. In addition, 2 metal parts were found that were thought to originally have been bow tie shaped. To determine this, however, they did not conduct the right investigation or a complete investigation, nor were impacts found on the wreckage of the MH17 from originally bow tie shaped fragments. Moreover, based on the investigation by the NFI, the chemical properties of these metal parts in the majority of the cases do not correspond with fragments from a warhead of reference Buk missile, nor were these metal parts compared with other missiles, despite there being every reason to do so. The defense asked a panel of experienced U.S. experts whether, based on the voluminous file, they could identify a missile. They considered that to be impossible based on the investigation conducted in this case and identify various flaws in the JIT investigation in the report and criticized the fact that only a Buk missile was investigated. The questions that remain are, how can it have been determined to be a Buk missile if no other type of missile was ever investigated? If even other types of missiles that could have caused the damage pattern and were in the area were not investigated. Moreover, how is it certain that it was a Buk missile if certain missile parts, if they were from a Buk missile, could only have been from the old Buk missile and others only from the new Buk missile? Then they cannot all be evidence, because if it was a Buk missile, according to the JIT scenario, it was one and not 2 Buk missiles, either a 9M38 or a 9M38M1, not a bit of both. And which parts would be evidence and which not? And why would the one and not the other one be evidence? Doesn't this become too random and very uncertain for a decision? In our view, the question as to whether it was a Buk missile cannot be answered with sufficient certainty.
And even if MH17 was hit by a Buk missile, it still remains to be seen which of the warring parties in the area launched that Buk missile. Yes, maybe a Buk tailor was in the possession of DPR forces. Videos and photos allegedly showing that were seen around the world. But we don't know at all whether that tailor fired the missile that hit MH17. There is no reliable independent evidence available. There's one witness who has demonstrably and on almost all important subjects given inconsistent and implausible statements, which is compellingly confirmed by a renowned expert in that field. And as one anonymous witness who has not been interviewed, of whom we know almost nothing. But even the little we do know is enough to inspire great caution. And there are phone conversations which aren't about the launch as such, but in which, after the fact, after MH17 crashed, the question is discussed of who could have been behind it and how. Phone conversations which make it clear that those separatists didn't have any idea of the cause either. Phone conversations which show that they took into account the possibility of Ukrainian forces being responsible for downing MH17, but then trying to blame the DPR for it. Phone conversations in which they fill in the gaps, based on suspicions and guesses of what might have happened. And we don't have the phone conversations of the Ukrainian armed forces. We don't know if they discussed the launch, or what else they might have discussed. The lack of such evidence, and that is the evidence that it was that potential DPR teller that fired the missile, the lack of that evidence is crucial. It cannot be ignored. And that might be different if the only possibility was it being that Buk tailor, that it's such a coincidence that there's no other possibility. But that is not something we can say here. Here, in these Dutch streets, a book tailor would be unique, and if it then turned out that a plane had been hit by a book, it must have been that book tailor. But how different is that in a war zone? How different is that when it's a fact that there were dozens of tailors in that area, of which only one or a few were in the possession of the PH forces, but most were in the possession of Ukrainian forces? And how different are things when it remains to be seen whether the book tailor in the videos could be fired, when it's plausible, and also happens more often, that in the context of military deception strategies, such military material, which can move but cannot launch, is used in order to deter the enemy. Under those circumstances, the possible presence of a tailor doesn't say nearly enough. It might seem as if MH17 was hit by a book missile, it could have been that tailor, but that's not proven. It could have been many other tailors as well. It is certainly not an established fact that it could have been that one tailor, never mind that it was that one tailor. Can it then maybe be determined based on from where the missile that hit MH17 was or could have been fired, in order to establish a link with the potential DPR tailor? To that end, it was investigated if, based on the damage pattern of the wreckage, it could be determined from which area the missile was fired. Public prosecution has decided that for those calculations only the book missile could be used, and that it had to be the new missile with a new warhead. The investigation was not done with other missiles. Before these calculations could be done, first they needed to know what the damage that such a book missile would cause would look like, and that expected damage pattern could then be compared to the pattern of damage on the MH17 wreckage. To that end, the JIT detonated a book missile in a controlled environment. That was the arena test, and that arena test, as we've said, did not go off without a hitch. But they did not redo the test, and the JIT ignored all advice to do multiple tests. So it remains to be seen whether the results of that one test are reliable and representative enough. Still, the public prosecutor felt no compunction in using the results of that one test in predicting the damage pattern on MH17. For the question that then arises in that investigation, which is matching the expected damage to the actual damage pattern on MH17, one major handicap is that not all pieces of wreckage were available, and that of the available pieces of wreckage only a fraction was used. That negatively affects the accuracy of the matching process. The manufacturer of the book missiles, Amazante, gained a lot of experience in the development of book missiles when it comes to the damage pattern and the exact flight path of the missile. Dutch and Belgian investigators did not sufficiently use that knowledge and expertise. That became clear during the interviews with all these experts, and it became even clearer then as well that there are differences between the kinds and amounts of damage on the pieces of wreckage investigated by the Dutch Institute and the Belgian Institute respectively. In addition, Amazante pointed out that more pieces of wreckage should have been used in the investigation and have been so far. The other investigators have confirmed that this would indeed have been better. But those new insights didn't lead to a new investigation. All three experts, using different methods, arrive at different potential firing sites. In view of Amazante's greater expertise, their comprehensive approach, and the easy-to-follow explanation they provided in reports and during interviews, we consider the results of the Amazante investigation to be the most reliable, as we have shown over 2 days of our arguments using many images and animations. We still found it necessary to submit all of that to the panel of experienced American experts, since we are not experts ourselves, they are. And they concluded that Amazante's calculations fit best with the damage pattern found on all available pieces of MH17 wreckage. This means that if it was a book missile that was fired at MH17, it can never have been launched from the area indicated by the public prosecutor. So what else is there to support the idea that it was that field? Even though the correct calculations show it could not have been this field. Is it the traces in one of the fields in that area? All of those traces could have been to do with other combat operations or other causes in an area that was on the front line and from which many unprotected battles were conducted in that period. Traces that can also be seen in many other fields in that area. Don't those traces then say much too little with regards to the cause of MH17 going down? In our arguments, we've tried to go back to the field that has been designated as the firing site by JIT. Because it's not possible to go there physically, we did that using the video of a journalist who was there a few days after the crash. We also went back to the field by interviewing this journalist at the Dutch investigating magistrate, one of the very few witnesses we were able to interview under normal circumstances. And we went to the alleged firing site with the help of satellite photos of the 16th, 20th and 21st of July 2014, as well as via photos that were made in June 2015 when soil samples were being taken. These sources of evidence were as close as we were able to get to the alleged firing site, not just because we were not able to travel there ourselves, but also because other sources of evidence are missing, sources you'd expect. We were not able to go to the alleged firing site based on forensic evidence for the launch, not based on satellite photos of the 17th of July 2014, not based on radar images, drone images, radar registrations, reliable witness statements, analyses of soil samples and phone conversations, because none of those exist. The conclusion is that a lot of information is missing, information that should be there if there had been a launch. And that the interpretation of the available sources of evidence, to the extent that they can be said to have any distinctive character, is at times contradictory, and that these sources of evidence are, if anything, a contraindication to the idea that such an impressive launch could have taken place there, of all places. So with all those uncertainties, how can we then exclude another cause? Has another cause even been excluded? None of the arguments on which the public prosecutor has based excluding the possibility that it was another missile from a different site support that conclusion. We cannot exclude another missile than that potentially available DPR Buk missile. It is possible and plausible that one of the 157 Buk missiles, or even another kind of missile of the Ukrainian armed forces, hit MH17 by accident. Contrary to the JIT scenario, we can then even explain how things could have gone so wrong. That they may have thought, and were proven wrong in hindsight, they may have thought that there was a reason to launch. We don't know if that happened, and we don't want to act like we do know. With our animation, we only meant to show that other explanations and possibilities are possible for the downing of MH17, other possibilities which, upon careful consideration, are less implausible than the JIT scenario, and that aren't at odds with the somewhat reliable evidence in the file. And finally, even if everything else could be excluded, and even if it could be proven that it was a DPR missile, there is still nothing based on which you could blame our client, neither factually nor legally. How would that be possible? How could he be the one to have to bear this responsibility if he had no say over the alleged firing of a Buk missile, had nothing to do with it, if he made no contribution at all to the firing? How can it then be said that he helped fire the missile that caused the plane to crash and killed all those on board, or that he was responsible for it? And how can the question of who is jointly responsible for firing the missile be answered in any meaningful way if we don't know who fired the missile? Even in the JIT scenario, we do not know who fired it. Yes, of course, the public prosecutor assumes it was a Russian crew of the 53rd Brigade, but that is an assumption, a supposition, a suspicion. We don't know. As one explanation, a public prosecutor has indicated that the investigation into the crew is not yet sufficiently advanced. That is public prosecutor speak for we don't really know. At least that's what it comes down to. Otherwise, why would that information not be in the file? And if we did know who the crew was, why? Is anyone still asking that question, I'm wondering? Why is that crew not in the dock then? What makes it easier, more logical, or better to prosecute our client rather than those who allegedly fired the missile? Nothing. It is not easier. Both our client and the alleged crew, from the perspective of the public prosecutor, are Russians living in Russia. Both are equally hard to prosecute. It doesn't make more sense either. The crew allegedly perpetrated the criminal act, so they'd be able to answer many essential questions left open. But we're skipping that crucial link in order to guess at why it was done, without any real knowledge, and on whose orders, and with what purpose. In order to determine, based on all that, if our client played a culpable role. The other way around would make more sense. And finally, it is not better either. Our client, that much is clear, was certainly not the one who pushed the button. Not the one giving the order to push the button, not the one giving permission to push the button, and not the one providing the weapon with which the missile was allegedly launched. Prosecuting him is not better then, at least not in the sense that you then have the person you really want to prosecute. It's not better if you're able to hold our client criminally accountable, even if at best he had indirect knowledge of the alleged presence of an anti-aircraft installation in a war zone. Instead of those who, in the JIT scenario, might be truly responsible. In other words, those who allegedly fired the missile, or those who gave the orders to do so. It is simply beyond us. What we're left with is a feeling of incomprehension and many reasons to doubt the public prosecutor's arguments. Many very good reasons to remain unsure, to conclude that it is really not certain what happened. And we know it is incredibly hard to let go of a conviction that everything is certain, that everybody who hadn't yet heard this side of the story thinks it is all certain, but it is not. Over the past 10 court days, we've shared all the reasons we see for rightly doubting what everybody thinks they've known for years. We've done our best to present all counter-arguments and contraindications to the JIT scenario, not a spanner in the works, but real good reasons for doubt. And it would be good if more people are now open to that than before. But mostly, we hope that the court still has sufficient room for doubt to assess all defences on the merits. That was it. And if you'll allow me, I'm just going to say a few words that aren't in my pleading notes, in order to thank some people. Yes, please go ahead. They are the following people. First, I'd like to express some gratitude, professional gratitude. First of all, to all the people working behind the scenes who ensured that all those images were visible here. Everybody responsible for safety here, that sometimes we were offered a real cappuccino, that last-minute pleading notes were printed, that everybody has been able to follow sometimes long sentences in translation, and thanks as well to everybody who's been involved in the organization of this hearing, which has by now lasted about 60 court days and about 40 interview days. And it might be unusual, it feels strange when expressing gratitude to not also express our gratitude to all the people at our firm, at our office, who have allowed us to do our work, who were willing to listen to all our considerations, were willing to spar with us, support us. For the Russian lawyers, who we couldn't have done without, unfortunately, because of the current circumstances, cannot be here today, and thanks to the experts who were willing to put their findings into writing. That wasn't true for everyone in this difficult case. And finally, the court and everyone else here who managed to listen to us for 11 days. We want to thank them for their patience and their attention. All right, thank you also for these words.
If I'm not mistaken, there are still a number of documents that you would like to submit to the court. Shall we do that first? Well, it's all the same, as far as the substance is concerned. Can I ask you what this is exactly? These are the digital annexes that we've been referring to, a USB pen drive. With all the material, says the President of the Court. We will take a careful look at all of that. I must say that in cases such as this one, I'd like to respond to what you said. A summary of what was put forward over the past 10 days. These words of thanks may seem somewhat awkward, but I appreciate that you spoke those words, and it's important to highlight the message that you are conveying. That it's important that everybody is open to everything you have put forward. That's important, and I'm very pleased to see that there's so many relatives present here today. Throughout those 60 days, the relatives have been paying attention to this case, and a number of you have attended almost all the hearing days. And now it's as if all this has come to an end, but that's not true. But this is just a point that we would just like to mark, and that's why I'm so pleased to see so many relatives. I'm sure everybody followed the hearing with his or her own ideas and feelings. That'll apply to today, and that'll remain the case. Nonetheless, we have always emphasized, and this is also an aspect put forward by the defense, that this trial is meant to administer justice, and for that it's important that we have an investigation, that we have defense, and that ultimately the court can administer justice. And that is important. And many relatives have also said this in their victim impact statement. So I'd just like to emphasize it once again, as you pointed out, that we saw and noticed at several points in time that this is how people indeed view this trial. And I just wanted to more or less summarize the atmosphere of this afternoon's hearing. Nonetheless, we have reached a point in which we will be proceeding to a next stage in the trial, and the court would indeed like to highlight a number of things today at the end of this block of hearings. In part, this is a repetition of what we just said. The court has noticed a number of things that we would just like to share with you. I'm going to proceed to the text that the court has prepared. Today, the defense has finished its oral pleadings. The defense has addressed many issues and raised many questions. The defense spoke about influencing, tunnel vision due to parallel investigations, excessive and preemptive press conferences. The defense spoke about being disadvantaged due to the fact that there's still uncertainty as to whether the case file is complete as a consequence of issuing the writ of summons at a late date by not examining the defendant first and dismissing the many requests for investigation. For those reasons and many others, a prosecution should not have proceeded to prosecution. It has also been argued that the investigation had a one-sided focus and was flawed, such as contamination and lack of expertise of the experts involved in the investigation, flawed testimonials and unreliable witnesses, and also due to insufficient compensating measures in order to offset the flaws that I just mentioned during the investigation that the defense was allowed to carry out. Evidence was subject to one-sided interpretation and exculpatory evidence was not considered, as a consequence of which there's insufficient evidence to declare the charges proven, according to the defense. Furthermore, the defense has argued that if the actions their client is accused of should be declared proven, these actions carry insufficient weight in order to establish any element of criminal liability as charged. And the defense closed its oral arguments with the conclusion that, therefore, their client should be acquitted. The hearing is now proceeding to a next stage, the stage of reply and rejoinder, which means that the public prosecution will respond to what the defense has put forward, after which the defense will once again be given the floor in order to respond to the prosecution. Counsel for the relatives will also be given the floor again in order to respond to what the prosecution and the defense have put forward about the submitted claims for compensation. Before the court suspends this hearing, the court would like to address the following issues. During oral arguments, the defense proposed to submit its own rendition of a redacted sentence of the statement of X48 before the investigating judge and to submit it in the form of an annex to the oral arguments. The court has already put forward its findings in this respect, but for the sake of clarity would like to repeat that the investigating judge has decided that the substance of the redacted text may not be made known, not even to the court. And so the court will not allow that this annex be submitted to the court, not now and not at a later point in time. Furthermore, the court would like to hear from the defense in which way it wishes to submit the 3 parts of the non-anonymized USA peer review report to the court, the prosecution, and counsel for the relatives, and which version it wants to have attached to the oral arguments and which version it wants to have incorporated in the case file of their client. We'll be hearing from the defense in that respect. Defense is speaking off mic. Yes, which version you would like to have attached to the pleading notes and which version you would like to have incorporated to the case file of your client. The prosecution. The court requests the prosecution to, in its reply, to explain in further detail the way the legal framework drawn up by the prosecution should be applied in this specific case, and in which way the conditions that apply to the different elements of the charge in the view of the prosecution can factually be substantiated. Furthermore, the court would like to request the prosecution to not only respond to the positions taken by the defense in oral arguments and substantiated to that effect, but also to comment on the following aspects. The court has noticed that for a large number, I'm talking about hundreds of objects that are part of the overarching seized items, the containers, the prosecution is requesting a contradicting decision for these objects because these objects have been registered as part of different overarching seized items. And so the court would like a specification of these objects in the request. And this only applies to the case of Gherkin because the seizures have been processed from an administrative point of view only in his case. And the court has received documents from a family in Australia that lost a daughter in the crash of flight MH17. These documents concern a claim for compensation that had already been submitted outside the Council for the Relatives, and the court will consider this in its reflections, and would like to hear what the prosecution's view is with respect to the claim for compensation. The same applies to the position of the prosecution concerning the incorporation of many documents as put forward and discussed by the defense. This concerns the USA peer review report, which is submitted in three sections. The ABA-1 report, a press release about the location of Strela 10 on 16 July 2014. The expert opinion into the reliability of the statement of witness M58, and an intercepted conversation dated 15 July 2014 at 10:52 a.m. between Pulatov and Khatchenko. The defense explicitly requested incorporation of these documents. The other documents have been attached to the pleading notes. And then in conclusion, the following point that is not only an issue in Pulatov's case, but also in all cases. The prosecution has explained that it deliberately decided to present charges with the primary charge being co-perpetration in a functional sense, and an alternative charge being the more executing co-perpetration. The public prosecution would like the court to first rule with respect to the functional co-perpetration. In view of answering the preliminary questions, the court is wondering in which measure the court, should it not consider the functional perpetration proven but the executing perpetration, in which measure the court can acquit for the first charge, the primary charge, because the executing charge is also part of that text, and the prosecution seems to have put forward the same primary and alternative charge. And the question to the public prosecution is to clarify this matter. So, as I just said, the hearing is going to proceed to a next stage, and the court will be suspending the hearing until 16 May 2022, and then we will have 3 days available for reply. In this block of hearings, first, counsel for the relatives will be given the opportunity to respond to the positions taken by prosecution and the defense concerning the claims that have been submitted for compensation. The court would like to be informed before we start this hearing block how much time the counsel for the relatives needs for that. And then the prosecution will be given the opportunity to respond to everything that has been put forward by the defense in its oral arguments. And the court would like to be informed by the prosecution whether there will be enough time to cover this and to respond in the 3 days that have been planned for this reply. I'm just looking towards that end of the bench. This is not something that needs to be answered right now, but If you expect an answer now, President of the Court, I can give you that answer right now. Well, if you have an answer, please go ahead. We can respond on the date as planned. That is the way we see it. Should things change, we will be informing you. But this is the way we see it right now. We can respond within the planning that we have, and we don't know exactly how much time we need. We want to be as concise as possible in order to be able to narrow down discussions. We do have a question for your court with respect to the request that was made to us, the explanation of the legal framework. Would that specifically concern participation or all parts and elements of the legal framework? President of the Court, as I just explained, the legal framework, let me put it this way, the connection between the legal framework and the prosecution's address, I think those things have to be seen in conjunction. And the court would like you to pay a bit more attention to the connection between the two, with respect to all the elements of the charges. So all the elements of the legal framework, for instance, all the forms of participation. That's clear. Having said that, we have put forward everything that needed to be put forward today, and the planning is clear, which means that the court will now suspend the hearing in all cases until Monday, 16 May 2022, 10 a.m.